Do complex legal issues hold you back? Let's get energized and bring clarity to your top legal questions. This is Law Talk with the Flock by Goosmann Law Firm.
Hello, I'm your host, Jeana Goosmann, a CEO, lawyer, author, and woman business owner, here to help navigate you through the law, your business, and life as a leader. For today's episode, I have with me my law partner, Dan Epstein. And today we're going to talk about navigating business disputes. Dan, welcome to the podcast.
Thanks, Gina. Thanks for having me, and I'm glad to be a part of it.
Dan, could you start by introducing yourself to our listeners?
Yes, of course. My name is Dan Epstein. I'm a partner here at Goosmann Law. I work in the Omaha office, and I am part of the trial litigation practice that we have here. My specialty so far has usually been litigation disputes involving companies, whether it be employment, construction, real estate. That's really what I've been doing the last 6 years here at Goosmann.
Very good. So we focus a lot on business to business disputes, and I know that you've led a lot of these cases for us, Dan. And we want to talk a little bit to some of the CEOs that might be listening on some things that they can do to try and help minimize the likelihood of disputes. And I think that's always interesting because from our vantage point, we see them when they go the distance, right? When they're in court and they have to battle it out. But what are some of the things that we've learned because of those disputes that CEOs might do to prevent them?
Well, obviously, as we know, you can never actually prevent every kind of dispute because sometimes, no matter how many precautions you take, the other side still might file a lawsuit. But there's a lot of things that can be done. Um, One, I think the most important, working backwards, is probably we were usually brought in at the end, right when the dispute gets filed or when there's no turning back. So I think the first best approach is actually for the business leaders to be working hand in hand with their attorneys. Start talking about issues before they arise, ideas before they arise, and that just not only starts with when you think there might be a dispute on a project or with an employee, but just even moving further back, all the way to when, let's say, you're entering into a contract. I think it's always beneficial if the company has their attorneys review the contract. And I'm not saying that just because we're looking for more work, but really the small amount of work that's going to take is actually is much smaller than the actual legal bill you're going to get later on when you're actually in a dispute. So
Absolutely.
it is much better for the client to bring something the attorney's attention, see what might become an issue, see what we might see as sticking points, parts that you might want to strike from the contract, parts you might want to add, or other things that we might see. Those early indications sometimes are beneficial down the long run when we get to something that already involved. And every attorney's kind of had that situation of, geez, had you only told me, or I'd only seen this, we would have told you not to sign this with X, Y, and Z involved. So I would say overall, having good communication between attorney and client works and can help reduce a lot of different issues before they sometimes can even arise.
I completely agree with everything you just said there, Dan. And people often ask me, what percentage of the firm is this or that? And I will say that our litigation and our disputes team, they are the most profitable part of the firm. And that usually is because people didn't use the business transaction team at the firm. And as a result, now they're in litigation. And people will also ask me who are, some of your competitors. And when I'm working with a business leader, business owner, a lot of times I'm thinking to myself, and I might even tell them it's you. It's you doing your own legal work without the guidance of counsel. And so if they don't fall into that trap, they're actually proactive and have a relationship and proactively seek that legal counsel. A lot of times there are things that can be avoided for sure. So great tips. Dan, let's talk a little bit about say they're in a dispute. What are some of the more cost-effective legal strategies for resolving disputes that don't jeopardize the company's financial stability? What are some things they can do that might avoid going all the way to the jury trial?
Well, one method could be some alternative dispute resolutions. That can range from arbitration, where that dispute is now taken outside of a trial setting, and we have an independent neutral serving as the judge or the jury and hearing the dispute. Sometimes arbitrations can go quicker than the trial setting. It can be limited discovery. It can be cutting more to the core. There's obviously a drawback to that speed can sometimes be that you're actually paying the arbitrator, unlike us paying a jury or a judge for their time. So that there is a trade-off between maybe getting the dispute done a little quicker than in a normal trial setting, where sometimes no matter how fast you want to move it, sometimes the court system is bogged down where both sides want to move something quickly and it just can't because of what else is on the judge's plate.
And
Another
time
one,
is money, right? Like the
it
longer
is.
something goes on in general, the more money it tends to cost.
Well, and witnesses can disappear, documents can disappear, memories can fade, people move. There's a lot of different things that the longer something goes on, the more issues that you run into as the dispute goes on. Another one could be just agreeing to mediation. Sometimes we're brought in to mediate cases before they are even filed in a lawsuit or an arbitration. And a mediation is where you're going to hire an independent neutral to help facilitate the back and forth and the exchanges of money potentially to try to resolve the lawsuit between the parties or the dispute between the parties. And sometimes having a neutral person in there telling both sides, here's where your side is really good, but here's where your real weaknesses are. And they're telling that to the other side. If both people can come in with a good mindset to try to get something resolved, an independent mediator can help the sides hopefully get that resolved before they delve into the litigation, whether it's arbitration or a trial, and all the legal expenses and all the time and money involved.
Great point. And Dan, why would somebody want to mediate versus just have their lawyer try and settle the dispute?
Sometimes having just the lawyers settle the dispute, we're talking lawyer to lawyer. Here's why my client's going to win, and the other person says, no, 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 here's why my client's going to win. Sometimes it's better to get everyone involved to simply say, I'm an independent person. I heard what they had to say, and here's what I'm telling you what they had to say. But I told them what you had to say in back in response, and they either had a response to it or they didn't have a response to it, or the response doesn't make any sense. Or in some of those cases, when our client is the one being stubborn, sometimes it's great to have an independent person come in and say, this is where I think you're wrong. This is where I think you're overstating your case. This is where I think you're overemphasizing some of these facts. And I don't think it's going to come out that way in a trial like you think it's going to, or it's going to carry as much weight as you do. Sometimes having that independent person coming in, giving their opinion about what your case is worth, how long it might take. And, it's always beneficial to have a neutral third party come in and say the things that the attorneys are always saying to the client. Some clients respond better when they hear it from someone else besides just their attorney or besides just opposing counsel.
You bet. And it can be tricky to change between zealous advocate for your client and somebody trying to get the case resolved and get it settled. And a lot of times when people lawyered up, so to speak, they're not necessarily in the mindset to resolve the case. And so that mediator can be that neutral that you described. Dan, let's talk about the role of collaboration between our legal team and business leaders in achieving the best possible outcome. Why is it so important to collaborate together?
I think a collaboration, really getting back to what we talked about before with the preventative measures, anytime that we can collaborate with our client, whether or not there's any disputes or issues, if we know what the goal of the company and the client is ahead of time, and we're working hand in hand, step by step with them along the way, it's a lot easier for us to help that client or that customer achieve their goals or their targets or what they're looking for. If we're only brought in as an as-needed basis when the fire's already started, it's a lot harder to help manage and get that client to where they're looking for. So having us as a professional, just like you would other professionals, you wouldn't try a tax advice without checking with your accountant. You wouldn't take medical decisions without talking to your doctor. Sometimes it's beneficial to talk to that attorney, walk hand in hand so they can tell you different things ahead of time. And from our perspective, the more information we have and the earlier we're brought in, the easier it is to give us, for us to give you advice as to all the different issues that you might encounter along the way.
Absolutely. And if the client didn't seek out your advice along the way and they call you after there is the dispute, that's where I think it's so important to get together and sit down, or even if you're meeting virtually, and talk about what the dispute is and what the client's goals are, what evidence there might be, what witnesses there might be, and how they can make sure they're preserving that, and helping to coordinate with you and getting in touch with those potential witnesses, and making sure that they're seamlessly helping to provide the documents to help you build the case and collaborate that way.
Exactly. It's always beneficial to, if the dispute's already started, the more you can work hand in hand with your client, the client's contacts, the easier it is for us attorneys to represent the client's interest in whatever dispute may be and give them proper advice as the dispute goes along.
And that clear communication back and forth both ways is so critical too, isn't it? Like the client's got something that they're thinking, it's really important that they share that with their attorney.
Yeah, we're not mind readers. I would like us for all to be, but we just can't do that. And there's a lot of moving pieces in some of these disputes. So sometimes you got a lot of different people with opinions, and the more we can get in touch with the client, figure out their wants, needs, goals, desires, the better.
So, Dan, with your decades of experience, what's one more tip you would give a business leader that you'd recommend from all your litigation?
The one I would say would be, don't take it personal. Sometimes in the business setting, we get to situations where the business leaders are sometimes taking it personal. And I know that's super easy to say since it's not us involved. Please don't take this personal. Make this a business decision moving forward. But a lot of times you got to take the emotion out of it and say, okay, what's this a business decision? Is it worth the effort to fight this? Is it worth the effort to fight that one issue? Am I putting my own interests above the interests of the company because I didn't like a former employee, or a rival has made me mad, or someone has said something against me or my company in pleadings or briefs that I didn't like and I'm upset about it? Like sometimes you're just going to have to check the ego at the door and say, what's best for this company and getting this dispute resolved. And sometimes it's just simply saying, okay, I'm never going to convince them that they're right and I'm wrong. And sometimes it's just better to get something resolved, and whether that's money involved or something else, sometimes the best thing to do is just remember to not take it personal, despite the fact that it is personal at times, to get the thing resolved for the best outcome for you and your company.
That's such a great advice, Dan. And I think that's one of the benefits you bring, being their outside counsel, is that you can counsel them on exactly that. Well, thank you, Dan, so much for coming in and sharing your insight today. Have a great day, everyone. Go make it worth it. Goodbye.
Thanks for joining us for Law Talk with the Flock by Goosmann Law Firm. We hope you feel energized and ready to soar past your goals. Become a Flock fan and subscribe to our podcast for weekly episodes. Learn more at goosmannlaw.com.